It's Wednesday, October 17th. This is Nilakil, the point of disembarkation for those intending to go to the Sabarimala shrine in Kerala. These videos, aired by news channels like Mathrubhumi, Asianet and News 18, show protesters stationed here stopping vehicles and forcing women to deboard. As the Sabarimala shrine opens for monthly prayers today, the first time since the Supreme Court verdict allowing women of all ages access to the shrine, overturning a decades-old practice, there is simmering tension. Kerala Chief Minister Pinarayi Vijayan has said his government was committed to implementing the court order and would not allow anyone to take law into their own hands. Chennai is staring at a severe water crisis. Private water tankers that account for at least 50% of the water supplied to the city and its suburbs have gone off the roads from Monday to protest the restrictions on groundwater extraction. The restrictions have been imposed following a Madras High Court directive that prohibits water extraction from overexploited and critical blocks. 130 bore wells, the Hindu reports, have also been closed down. In Chennai, an estimated 80% of households are dependent on packaged drinking water. In a setback to the Congress in Goa, two MLAs, Dayanand Sopte and Subhash Shirodkar, have switched camps and joined the BJP. The two have resigned as MLAs, bringing the strength of the House down to 38. The Congress, which was the single largest party with 16 seats, is now on par with the BJP that has 14. This put paid to the Congress's hopes that restless allies, in the absence of an ailing Manohar Parrikar, would switch camps. The party had, in fact, a few weeks ago staked claim to form the government, stating that the administration has collapsed. AAP is Kangal, declared Delhi Chief Minister Arvind Kejriwal as he launched a crowdsourcing campaign to help his cash-starved party fight elections in 2019. Asserting that the Aam Aadmi Party doesn't depend on money from, quote, corrupt industrialists, Kejriwal appealed to supporters and volunteers to donate to the party. The party has asked volunteers to give names of 5 people who will donate a minimum of 100 rupees on a monthly basis. The Delhi Chief Minister said this method of raising funds will become a model for the world. Harvard University is being sued over its admission policy. The plaintiffs, a conservative body, have accused the college of discriminating against Asian American students by holding them to higher standards, as they are usually stronger than applicants of other races in academic and extracurricular categories. Harvard has said it seeks the formation of a diverse student body, but denied the use of racial quotas to shape incoming classes. The case, expected to reach the Supreme Court, will ultimately shape the future of affirmative action in US college admissions. In 1978, the US Supreme Court upheld admission policies that consider the race of students, as the practice traditionally benefits African American and Latino students. A wakalatnama is a written document authorizing a lawyer or lawyers to represent the client. Now, the wakalatnama in the criminal defamation case filed by Minister M.J. Akbar, authorizing as many as 97 lawyers of major law firm Karanjawala and Company, has been viewed in many quarters as intimidation tactics. Though the firm clarified it was standard practice to print names of all lawyers and that only 6 will appear in the case. Be that as it may, the perception of intimidation comes from the increased use of criminal defamation cases as a tool of harassment with an intended chilling effect, that of silencing others from speaking up. There is a term for it, coined in the 1980s in the United States, called SLAPP, or Strategic Lawsuit Against Public Participation. It is a lawsuit that is intended to censor, intimidate, and silence critics by burdening them with the cost of a legal defense until they abandon their criticism or their opposition. SLAPP typically involves a powerful corporation or person filing a suit against say, journalists or environmental activists or communities that are speaking up. Many jurisdictions world over have enacted anti-SLAPP laws with the view that these suits have a chilling effect on free speech. Criminal defamation is one form of SLAPP. Sure, defamation laws exist to combat malicious lies, and there is a civil remedy available for it. But in several countries, including India, defamation is both a civil and a criminal offence. Section 499 and 500 of the Indian Penal Code deal with defamation as a criminal offence. BJP leader Subramaniam Swamy, Congress President Rahul Gandhi, and Aam Aadmi Party Chief Arvind Kejriwal had approached the Supreme Court challenging the criminal defamation law as having a chilling effect on free speech. The Supreme Court dismissed their petitions in 2016 and upheld the law. In a critique of that judgment, lawyer and author of Offence, Shock or Disturb Free Speech under the Indian Constitution, Gautam Bhatia writes, "The case against criminal defamation was and continues to be very simple. Article 19(2) of the Constitution permits only reasonable restrictions upon the freedom of speech. For a law to be reasonable, it must demonstrate a degree of proportionality between the restriction and the goal that is sought to be achieved. Criminal defamation fails that proportionality test. Criminal defamation is disproportionate because it uses the criminal law to prosecute a wrong that is purely private in nature. A private wrong is one that is purely between the offender and the victim and has no implications for the society at large. For example, he says, if I fail to control my dog and it bites you, then you may sue me for compensation in a civil court. Society, the state, and the criminal law have nothing to do with it. However, if I murder a person, then it is not just about one individual taking the life of another, but has ramifications for public peace, order, and security. This is why murder is a criminal offence, involves a jail term, and is prosecuted by the state. The sole purpose of criminal defamation is to protect private reputations. This makes the criminalization, with a jail term to boot, a public law remedy for a private wrong and therefore disproportionate." Lawyer Apar Gupta writes, "Given that a civil remedy to defamation already exists, no purpose is served by retaining the criminal remedy except to coerce, harass, and threaten. A criminal remedy would allow a potential complainant to file a case anywhere in India, which would be pending for years, requiring the accused to be personally present along with a lawyer on each date of hearing. Most cases are abandoned after a certain number of years. Till the point the case survives, the cost of a criminal trial is enormous on the wallet, time, and ultimately the mind of the accused. Criminal defamation does act as a deterrent, but not to defamation. It stifles legitimate speech itself, given that it almost never results in conviction. The chilling effect it causes is beyond doubt, and for the court to state otherwise is absurd."